Today is going to be an exciting day because we have in our midst a great scholar from Rwanda. In our mediation training, we usually end the mediation program with a reflection on the Gacaca court processes. That means the kind of indigenous traditional conflict resolution that was developed in Rwanda after the genocide of 1994. And the Rwandan people looked into their traditional systems of conflict resolution and were able to successfully revitalize the Gacaca courts processes. And that was really helpful in national reconciliation, healing, post-genocide, trauma healing, and that process is very outstanding, an example to a testament to the importance of the traditional systems and processes of conflict resolution. Today we have a distinguished speaker, Professor Dennis from Rwanda, who is going to be sharing with us, give us a first-hand account of that very process. Just to remind you that he was also a part of the development and revitalization of the Gacaca process. He was deeply involved in the Gacaca court process after genocide. And so, ladies and gentlemen, please permit me to invite a distinguished speaker for today's conference, Professor Dennis Bikesha. He is the Dean of School of Law and a lecturer of law at the University of Rwanda School of Law in Gikondo campus in Rwanda. Professor Dennis, please come up.
Good morning. I'm very happy indeed to have this presentation about Gacaca courts. But also I'll add some information about Abunzi, and it is also related. I worked with Gacaca courts from 2004 up to the time of their closure in 2012. Basil is calling me Professor Dennis. Maybe that is not yet my title. In 2012, when I finished working with the Gacaca courts, I went to study in Tanzania, nimemwona mheshimiwa, at University of Dar es Salaam, where he teaches at the School of Law until recently, last year in 2017. But I started teaching at the University of Rwanda in 2014. So the thoughts I have, the information I have about Gacaca courts, mainly Gacaca courts, it is double-edged. One is that I worked with the courts, but two, I also carried out a research on the same courts. As for the mediation or the Abunzi committees, I have not worked with them, but at least I have information as Rwandan, but also as an academic. The paper is mainly, when I designed it to be more of informative, and it is showing how Rwandans have participated in resolving their disputes, especially through Gacaca courts, but also since Gacaca courts closed, it was thought necessary that the Abunzi committees continue to work in resolution of disputes, not in genocide cases, but this time in ordinary cases, because where there is a human being, usually, always there is a conflict, and that conflict has to be resolved. So that is mainly what we are going to discuss. I can give you some information I have, and then I will maybe open a discussion on that. I can use this opportunity to apologize because maybe I'll be here for a short time after my presentation, because as I noted, I'll be traveling to California, Sacramento, to present another paper on reconciliation. It's related. So the paper is tomorrow. I have to fly today, and my flight is today, so I can't keep here, although that would be also desirable. I prefer beginning with that picture that was taken during the activities of the Gacaca courts. And the picture really depicts how Gacaca proceedings were taking place. What you see in the picture, you know, also that's funny with the teachers. You can't keep a teacher standing like that. Sometimes it's not easy. Yeah, so this picture, what do you see in the picture? One is that you see people, very few people are sitting on chairs or on a bench. And most of the rest are sitting and standing on grass. And that is the etymology of Gacaca, because Gacaca means the type of grass where people were sitting to resolve their disputes. So I prefer this picture to many other pictures I may have taken. We have maybe people sitting on chairs because, as someone mentioned, we can't be static. People have to take notes, so you cannot take notes when you are sitting on grass. You better take notes like the judges you see, wearing the sashes in the colors of the national flag of Rwanda. That is also where I included the flag. You can get the relationship. So the only identification for the judges is that they are wearing those sashes. Otherwise, they are like you and I. And you can see two persons standing just before the judges. You can interpret them as parties in the case or even witnesses in the case. And you can see that this photo also was taken under trees. Gacaca courts hearings were taking place in such openings where many people could be accommodated, but also to hide from maybe a lot of sunshine and so forth. So I usually begin with this picture because it shows someone who has not attended Gacaca sessions to get a picture of what happened. So when we look at the background, we see these courts, the Gacaca courts, coming from the Rwandan culture, the origin, where people, of course, were sitting and resolve their disputes. And in the aftermath of the genocide against the Tutsi, we had many meetings because people did not know what was going to happen as far as justice was concerned. So meetings, how can we render justice? But people said, let's go back to our tradition and see how we can resolve this dispute. It is estimated that over 1 million people, Tutsi and moderate Hutu, the Hutu that were fighting the ideology of genocide, were killed. There are many genocide memorial sites, and this picture was taken in one of the memorial sites, genocide memorial sites in Rwanda. We have a lot of memorial sites that are arranged in this way, and we have many other bodies that were buried. And we have other bodies that we do not know where they are. Then also this is showing you that in the aftermath of the genocide again, where 1 million people have been killed, they can't be killed by 10, 100 persons or less. They were killed by many people. So in around 1990s, we had over 120,000 detainees who were, this is a picture of the detainees, this is how they look like, who were waiting for trial, waiting for justice. Maybe some of them are innocent. That's the importance of justice. But the problem was, how can we render justice with that machinery in the country, where we have, after 1996, where you have judges 841, and remember, also ordinary crimes have to be attended to. But people tried, because in 1996, first of all, there was no law to punish genociders. So what was done is that on August 30th, 1996, an organic law was established in Rwanda to begin trying genocide cases in ordinary courts. And in a period of 5 years, the courts tried and managed to reach 6,000 cases, genocide cases tried. But there was a problem. The problem was, at that speed, how can you manage, try the 120,000 cases that were pending, 100 years plus? And then, if you try cases in a period of 100 years plus, is that justice? Because we have the common slogan, justice delayed is justice denied. So this is why there was a need for something as an alternative to be done. So what happened is that the President of the Republic by that time convened meetings, and people started discussing how justice can be rendered. And Gacaca courts came as an alternative. We say, well, if we visit our tradition, we can come up with maybe some modifications. I remember the professor was telling us that culture is never static. So this is the same with the Gacaca courts. It was not static. And in 2001, Gacaca courts were established. They were established, but the law of 2001 was repealed because after a pilot of activities, it was found that many things could not be in order if the law continued the way it was. And in 2004, the law that replaced the former one had at least to be modified also, but not to the extent of being repealed. And one of the modifications that were made is one concerning the judges. In 2001, the law provided for, I remember, 19 judges, 19. And it became a problem because those were very many, and there was supposed to be a quorum. Maybe some could miss, and it was slow. So the sitting bench was composed to be 9 judges and 5 disputes. I mean, substitutes, meaning that if the quorum was not present, then people could come from the replacement. Then categorization also. You know, genociders did not play the same role. Therefore, punishing them or giving them the same punishment also would be unjust. There are those who planned genocide. Mainly those are supposed to be category 1. There are those who did not plan but executed. They were told, go and kill, that they went to kill. You can't also put them in the same category with the rest, the planners and organizers. There are those who never killed at all. They committed crimes that are related with property. And their hands are not all that dirty with blood. So that is why this law also came up with categorization, such that at least those who were severely involved in the genocide can also be severely punished. Then Gacaca courts were given a mission that had the following elements. That is to disclose truth about genocide events, to speed up the cases because you remember it was an issue. Then to eradicate the culture of impunity. Otherwise, people would go on, kill. Rwanda has a history that the Tutsi started being killed in 1950s. In fact, in around 1959, over 200,000 people, Tutsi, were killed. But no one bothered. Instead, maybe those who were killing could be like elevated in their positions and so forth as a promotion, as if it was a good thing. Then also to reconcile and strengthen unity among Rwandans was one of the elements, as well as showing the capacity of Rwandans to resolve their own problems. The activities of the Gacaca courts were organized in 3 steps, such that we have a step that you could call maybe as part of investigations. So information was collected from house to house. And after the collection of information, then the information was categorized, and the suspects also being categorized according to the information. But the categories were also there affected in 2 ways. One, categories were affected in relation to how someone participated. If you participated highly, then you go to the higher category. But also depending on the caliber of the person who participated in the genocide. If, for example, you were a minister, if you were a member of parliament, and you participated in the genocide, then that means that one is an aggravating circumstance, and you are supposed to be in the category 1. Then, of course, trials is another step. Trials began. We have also to note that according to this law, Gacaca courts were brought closer to the people. It is important to know that when people have to travel longer distances, again, it loses the essence of justice for the people, because they have to participate when they are not coming from very far. But also we have another important thing about minors, because minors also, it has to be presumed that there is no minor who has to take a decision after thinking like an adult would think. The thinking capacity is still low. So when I have two persons, an adult and a minor, maybe I will be in a position to convince a minor before the adult is convinced. So the punishment that was given to a minor who was more than 14 years, because the minors below 14 years during the commission of the crimes were not supposed to be tried. So those who were tried, they could get a half of the punishment that was given to an adult who committed the same crime. Then what was also important is that there is a procedure for confession, guilty plea, repentance, and even apology. So if someone apologized in the confession, then the punishment was supposed to be lowered. And to some, they could not even go to prison, because there is what was introduced as community service, TIG, for those who know French, Travaux d'intérêt général. If you go in position to judge these courts, as I mentioned, this is a paper that is telling a story, a success story, about what happened. One, we need to note that although we saw that when Gacaca courts were thought as a measure, we had 120,000 cases pending for trial. But when Gacaca courts completed their work on June 18th, 2012, they had already completed 1,958,634 cases. So assuming these courts did not work, how many years could be taken to have So I was talking about the work done. If you estimate, maybe in simple arithmetic, which I cannot easily, you know, the cases with lawyers, which I cannot easily estimate, but if you get almost 2 million, 1,958,634 cases at a pace of 6,000 cases per 5 years, then this would take hundreds of years to be completed. But at least you can see in a period of 10 years of Gacaca Court's tenure, that is the work that was done. And also, when you go to the work, you will see about how many were convicted, the percentage of acquittals, and so forth. Then also, this is what I was telling you about community service. In fact, when you get reports, when I was working with the Gacaca Courts, I was also a member of the National Committee of Community Service, and we were getting reports per year. The government was saving billions of money through the genociders who pleaded guilty and confessed, and instead of going to prison. So there is a difference between these you see and the ones you saw in the uniform, in the pink uniform. The ones you saw in the pink uniform are in prison, while these ones are in their in camps or in their homes doing community service. But they killed, they are killers. In fact, when you visit, if some of you visited and you see them dancing and welcoming you, you even forget that they are killers. It's very interesting. The other impact we could say about Gacaca Courts is the culture of citizen participation. I do agree with that person who is tracing the citizen participation aspect in a way of cementing democratic aspects. Because democracy means participation of the people. So if you have people that are participating in resolving their problems and planning for their own good, then that is democracy. In fact, what we can interpret is that we have a common slogan again, that justice is rendered in the name of the people. But by Gacaca Courts, you could say justice is rendered by the people. And if you also borrow the common definition of democracy, it is the justice of the people, by the people, and for the people. They are doing everything. The judge is a local person who has not, some have not even gone to school, but they are chosen on basis of integrity. The prosecutor, who is also assumed to be a prosecutor but a lay person, and even the advocate, they are all coming from the people. So the participation, and this has affected other projects that will need citizen participation. For example, the Abunzi, which we can see that was also established in 2004. The establishment of the Abunzi is constitutional because Article 141 of the Constitution is the one that provides for Abunzi committees. Like I explained what Gacaca means, Abunzi in Kinyarwanda means to reconcile, those who reconcile. And it is in this aspect that this institution is in place. It was first established in 2004. Then the law that established that institution was changed in 2006. But this 2006 change is not substantial because it only concerns the structure which the Abunzi based and were related to the administrative entities, and the administrative entities changed in 2006. In 2010, 2015, and the current law is the one of 2016. Rwanda is known for being gender sensitive. It has been always the first globally to have like parliamentarians representation of women. We had 64.8 last year. This time we have also above 60. But also to make sure that all decision-making positions have women represented, the Constitution has provided that at least in every or at every stage where decision making is needed, there has to be 30% of women representation. Abunzi also, Abunzi law provides for that. So in the Abunzi, in the mediation, in the committees, you have necessarily to have 30% of the committee. Then when you look at it, it is countrywide, composed of 17,941, because every committee has 7 members, and you get countrywide. Among those, 9,988 are male, making 55, but 67%, making 55%. Then 7,953 are women, and there you can see not only 30%, but it has been raised to 44%. Abunzi committees are occupied by men and women who are working on voluntary basis, according to Article 4 of the law of Abunzi, and they are elected by their peers. There are some amendments I mentioned that were made, and these are for the benefit of the internal arrangements of how Abunzi committees can work. And we also have to note that Abunzi is being effective because the Abunzi committees, because we have 83 of the conflicts that are settled at the Abunzi level. Why were Abunzi committees created? Because there was a lot of backlog in the ordinary courts. So this means 82% of the civil conflicts is reduced from the work that would otherwise be done by the courts. And maybe 18% goes to the courts, but even out of 18% that goes to the courts, 56% to show the effectiveness of the committees does not change in decision making. So they will confirm what was suggested by the committees. Abunzi have challenges. Some of the challenges are concerned with the framework, the legal framework. Others are concerned with the logistics and so forth. But if I can conclude, I would say Gacaca courts, first of all, it is a system that when I was carrying out my research, I found that at least it has contributed to the 6 T's, which I have called truth, trials, trust, tolerance, time, and transformation. All these can be elaborated, but at least you can see everything was to discover truth, the number of trials that were carried out, the trust that is currently in the country, the tolerance, the time that was saved, and even the transformation. So thank you so much.